Good morning, Mort. Thank you so much for being here today.
My pleasure.
Really appreciate it. As you know, the whole function of this exercise is to give some light to people on what was really happening behind the scenes that you don't ordinarily get the benefit of learning about just by reading about the case. So obviously Omnicare is quite interesting, and I'd love to start with perhaps you letting me know at what point were you brought into the matter?
It started in the fall. The events that are outlined in the case are 2002 spring and summer. Omnicare got interested in this in the fall of 2001 and had made some overtures to the NCS people and tried to get information, tried to negotiate a confidentiality agreement. We were unsuccessful because they insisted on I forget whether it was a 2 or 3 year standstill. This is in some ways ancient history now, so I apologize for not knowing all the details.
I understand, no problem.
And we told them we wouldn't do that, and we offered some alternatives, shorter term NDAs. We also pointed out the fact that once we got information, it would be very hard for us to do anything on a non-consensual basis. And they insisted on their form, or they weren't going to deal with us. So we stopped talking to the company because we weren't really getting anywhere, which is when we went to the creditors committee, again in the fall of 2001.
Why do you think they were so resistant to any negotiation with you on an NDA?
I think they didn't want Omnicare to acquire them, and subsequent events I think bore that out. But Omnicare had a certain reputation in the industry. They were tough. They were aggressive in negotiations. The business is also. It was a very simple business. It was a wholesale pharmacy business. The value was all in the synergies, which meant that synergies is euphemistic for you were going to basically chop a lot of people and consolidate their contracts into your system with your people. And Omnicare was very successful in doing that, and had people that were very efficient in doing that. And most target companies didn't like that prospect.
And there had been some history.
I don't know if there was history with NCS
directly,
specifically.
But the reputation you talk about.
Yes, I mean Omnicare was by far the biggest player in an otherwise fragmented market, and that was the Omnicare business plan.
Right.
It was essentially a roll-up. You went around and rolled up a lot of really family businesses. This was institutional pharmacy, which is euphemistic for you sold drugs to nursing homes.
Right.
And it was generally a local business. You'd have the local nursing home, and they'd go to another local pharmacy and get their product. Omnicare institutionalized that business. They had distribution centers. They had people that recommended certain drugs. They got more efficient in their purchasing power. They ended up being the largest buyers of drugs in the country from McKesson and Cardinal and those distributors. So they really brought a level of professionalism to the business, and they got very large as a consequence. A lot of people sold to them, not because they were forced to, because these were private sales, but because Omnicare could pay what to these local pharmacies looked like a huge amount of money, but to Omnicare, given the synergies, were reasonable prices.
Understood. So, all right, so unsuccessful in negotiating fair terms in your mind with them, so you go off to the creditors committee. Can you tell us a little bit what your plan was with respect to your negotiations with them?
Well, there was nothing secretive, underhanded about it. Omnicare wanted to acquire NCS. They had a sense, obviously without doing any diligence, without access to private information. But given their experience, they had the sense that this could be a lucrative transaction
Right.
for them, given the potential synergies they thought they saw. So they simply wanted to buy NCS, and they wanted to talk to anybody who was willing to talk to them to acquire the company. The company wasn't willing to talk to them, so they found, at least initially, a willing participant with the creditors committee.
And how did that work out?
Well, the creditors, I think it worked out well for the creditors. I think they negotiated with Omnicare. They got a price from Omnicare, and then the company, with the creditors' involvement, turned to Genesis. And obviously, they knew what they had in their pocket. So there's much talk about the stalking horse. I think they used Omnicare as a stalking horse. They had the Omnicare bid. They never bothered to go back to Omnicare, and they used that the bankruptcy bid as a basis for their negotiations, I think, with Genesis.
Well, with respect to that bankruptcy bid, when you call yourself that you perhaps were the stalking horse, the terms of your offer, what were the conditions? Do you recall if there was anything significant?
No, not really. There was nothing unusual in the discussions. It was, what do we need to do to acquire this company? And in the same way that any acquirer would approach
Right.
any target, let's figure out how we can do this deal. Obviously, the creditors wanted as much as they could get, or the company, I presume, since they never spoke to us,
Right.
wanted as much as they could get. And from the buyer's perspective, we wanted to pay as little as we could in order to acquire the company.
Did Omnicare, any representatives of Omnicare have any prior dealings with any of the individuals on the
NCS,
creditors committee?
On the
Yeah.
creditors committee. I don't know. There was some familiarity with Judy Mencher, who was the lead
Right.
on the creditors committee, but I don't know if there were prior dealings or that the bankers knew people on the creditors committee. But we had a few meetings with them. It was all amicable. Didn't go anywhere, but it was all amicable.
Well, why do you think after all that meeting with the creditors committee, they again ignored your client and went right to Genesis? That's why I asked, was there any prior dealings that maybe led to some history they wanted to avoid?
I don't think so. I mean, I think they were playing it as creditors would. They got what they thought they were going to get from Omnicare without sharing any information.
Right.
They then turned to Genesis. I think the reason we knew something was going on was that Judy Mencher came back to us late in July, and I think she did that because she was playing the role that you would have thought that the board would play. I don't think she liked the Genesis deal at the point in time that she approached Joel. I don't think that they were paying the creditors out completely. So I think she went back to Omnicare at that point and contacted them and said, gee, you really got to come in here and do something. So, the case, the facts would indicate that Omnicare came in at the last minute
Right,
and Omnicare just threw in this conditional bid. I mean, if someone had approached Omnicare in March, April, May, or before they signed an exclusivity agreement and said, look, we think the equity has value, we can prove it to you, sign a standstill, a short-term standstill, not a multi-year standstill, and get some information, I think Omnicare, I know Omnicare would have done that, but nobody reached out to Omnicare.
Well, do you think with the encouragement of the creditors committee that NCS might have backed off on the length of the confidentiality agreement and standstill?
I don't know what the interaction was between the creditors
Okay.
committee and NCS. Look, it's very clear that NCS didn't want to sell to Omnicare
Yeah.
for whatever their reasons. And the case is is replete with references to we want to do this to make sure that we don't get a bid from Omnicare. I mean, what strikes me as an odd way for a board to go about an auction, but it's explicit, and it's explicit in their. It's certainly from the Genesis side. We want these things because we want to make sure Omnicare doesn't bid, and the company went along with that.
Well, the facts do, as it's presented in the cases, you do read it, and it sounds like you come in at the last minute, very conditional, that a board would be silly to take yours over a much more certain offer. And why do you think it was referenced that way? I mean, why? Forget that. But what was going on that the presentation was so anti?
Yeah. You know, we all pick our
Okay.
facts. We're lawyers. We know how to pick facts and weave a story. Their litigators picked facts and weaved a certain story, and the court
Bought their story.
The court bought their story. Why they would, in the face of legal precedent, have acted the way they acted, it's counterintuitive to me vis-a-vis the minority shareholders. You know, clearly the board and management did not want to be acquired by Omnicare. You know, in this day and age, I don't think that would have happened. You know, given the corporate governance environment today, it's inconceivable to me that you would have replicated that fact pattern. Back then, people were still pushing the edge of the envelope to see what they could get away with, and you know, boards were a little more complicit with what the senior management wanted to do. Again, I don't think that would happen today.
Mm-hmm. Well, as you said, the set of facts that were noted in the cases, the story that was bought, so we say, or that everyone thought was credible that went into the case. Did you?
And I would note when we talk about the
Please.
facts, if you look at the Supreme Court decision, which I actually reread in preparation for this, the decision rests on a unical analysis, and they assume the facts. But there, in my rereading of it, there's a certain skepticism in the facts. I mean, the Supreme Court says, look, we're going to assume these facts, but you know, among the facts we're going to assume, and the fact that they discharged their fiduciary duty, we're going to assume that it was all okay, notwithstanding the fact that they signed an exclusivity agreement, they acceded to all of the demands of Genesis, they abandoned their stalking horse plan. You could look to me, what the Supreme Court seems to be saying is, I'm not so sure about these facts. I mean, there may be a different way of looking at these facts. And then they go on to say, and by the way, given the fact that they were improving and that they were no longer really on the verge of bankruptcy because they were getting value for the equity and they were convincing at least one buyer to pay for the equity, that why wouldn't you at that point have reached out? That's really kind of an aside in the case because they're focusing on the unical analysis. But I think there was some skepticism, at least in the majority, as to, in looking at those facts. Yes, you could look at it and say, well, gee, Omnicare was this big bad person and they just wanted to buy it in bankruptcy and they made this bankruptcy bid, and then, oh, gee, all of a sudden, 6 months later, they reappear with a conditional offer. A skeptic might look at that and say, well, gee, what happened in the interim, and why exactly didn't you attempt to contact them in the interim? Why didn't you attempt to re-engage them? I read a little of that into the decision.
How about the fact that Genesis truly, basically gave NCS practically no time to make a decision, basically said, look, take it or leave it. Or, I mean, there was a risk, wasn't there, if NCS did not accept Genesis? They weren't sure about you at that time when they were making the decision.
Putting the best light on it from their perspective, the answer to that is sure, yes, I get that. But I guess I would point out a couple things.
Sure.
One, I've never seen an ultimatum I've been doing this for close to 45 years that someone really followed through on. Now, maybe they really were going to, maybe they really were not going to put themselves in a position where they were going to have Omnicare come in, but I think there's at least some obligation to test that notion. And that assumes that there was no history here and Omnicare is just sort of piling in at the last minute. To me, this is, again, if you look at the case law, ACE, Phelps Dodge, QVC, those opinions are replete with references to the fact that you can't, in a sense, create a situation where you force a decision and then say, gee, I had no way out. And in my mind, this case is on all fours with that language in ACE, where this was created by the fact that this board and their special committee basically had the same advisors as the company, which to me was curious. And after they were established in March, March, April, May, June, I forget when they signed the exclusivity at June or in July, you would not reach out to someone that everyone acknowledged had the ability to pay the most money and at least give them another shot. I mean, if for no other reason, if I were counsel on that side to create a better record, I would have reached out to Omnicare.
Okay, but Genesis had some tough negotiators. Right?
That's the world that that's the world of M&A.
Right.
There are no cupcakes in this business.
Wouldn't you think it's possible that based on the Genesis presentation and the reputation of its counsel that NCS might have thought reasonably, might have believed that the ultimatum was for real?
And again, putting the best face on it, let's assume that it was. That ignores the fact that for 3 or 4 or 5 months before they got that ultimatum, they did nothing to reach out to Omnicare. The other thing that ignores in kind of the real world of M&A, in my view, is the facts that weekend were somewhat humorous in a way, but we mentioned contacts. Joel says, you got to put a bid in, you got to put a bid in. So we contact all these people and nobody's responding. Now, it's unclear to me time-wise when exactly that exclusivity agreement ended, but it was a Friday. It got extended that day. And I'm not sure whether it got extended before we started reaching out to them or afterwards.
You never found that out.
No, and the only way we got to them is my brother had an office in the same building as the NCS people. So it was a Friday afternoon. We got his secretary to come back in the office, and we faxed the thing to her and told her, please don't read it, and put it in an envelope, put it under the door. So that's the way we got the offer to them.
That's something.
So they had that offer. It was like it was for $250 or $3 more than what they were getting from Genesis. And at that point, so okay, you get an ultimatum. We got to finish this deal by Sunday night or Monday morning when we got to announce. We've all done deals. This is not a complicated transaction, and I understand the due diligence condition. But as you negotiate out a merger agreement, you're going to get diligence. I mean, there are going to be reps and warranties. There are going to be schedules. It was not insurmountable. We've all done deals over a weekend, and we've all done deals where we're negotiating with 2 people simultaneously. And you got one conference room going with one group and another conference room going with another group, and you see where you end up at the time of the deadline. So the fact that they didn't even engage in anything like that, and, you know, and I know they go on and on about conditionality, you know, the due diligence condition. But what's interesting to me also is there's language, and you know, by the Chief Justice Veazey in the Paramount decision, saying, look, you at least have an obligation to examine that conditionality and determine whether it's really a problem or not. You know, nobody came to us other than, you know, Judy Mentor saying you got to take out the diligence condition. You know, Omnicare had a board. Omnicare had an obligation to its shareholders, and you know, Joel Gamunder did not control that board completely, and you know, the board didn't want to take that condition out. You know, interestingly, the advisors told him to do that because he was going to get his diligence anyway in the course of negotiating a merger agreement. But the board wasn't comfortable with that at that point in time. But they had NCS could have come to us and said, you know what, let's talk. You know, instead, what they did was they signed an extension of the confidentiality, the exclusivity agreement, and said, oh, gee, you know, we can't talk. You know, I get it. I get what Genesis wanted, and I suspect that the senior management knew there was no job for them at Omnicare. I don't know if there was any discussion of that with Genesis, but clearly they were done if Omnicare bought them. But if you look at the cases, and again, to me, in analyzing this, obviously you want your client to win, and you know you want to do the best for your client. But I've never really understood this negative reaction to Omnicare. To me, it was just another in a series of cases. You know, Phelps Dodge, Ace, QVC, Macmillan. You know, go back to Anderson Clayton in the '80s. There's a series of cases that just say, look, you know, there are a couple of bidders. You just can't block one of them out. You can't do that. And to me, that's what this case was all about.
So you were very surprised with the Court of Chancery's rulings.
Yes, I was. Yeah.
Really?
I mean, I thought we had a very strong case based on the precedents. Now, again, people, as I said, you know, lawyers are good at picking their facts and presenting their narrative, and you know, they obviously presented the narrative that we were last-minute bad guys. We wanted to just, you know, we wanted to take it in bankruptcy and screw the equity, and we came in at the last minute, and with this highly conditional bid.
Right.
But it just as an aside, the conditionalities, it's also sort of humorous to me because when you read the Genesis agreement, there was a working capital condition, which you could pick up 1,000 or 10,000 or 100,000 merger agreements. You will not see that in any other public company deal. So you talk about conditionality, and nobody really focused on that. Certainly the court didn't, and you know, the NCS Genesis people weren't going to go out of their way to point that out. So you know, they painted a certain narrative, and you know, the vice chancellor accepted that narrative. Was I surprised? Yes. You know, I didn't think we were doing anything. We were creating new law, and I think the Supreme Court decision is consistent with that. That this isn't new law. This is, you know, this is a straightforward unical unitrin analysis.
So I suppose you do believe that without a fiduciary out, a board can't lock itself up in quite the manner it did.
Yes, and again, that's consistent with a line of cases going back at that point 15 years, and it was in the context of a shareholder vote. You've got to give the shareholders an ability to vote. So, you know, there are references in the case law to, you know, there might be a situation in which the board can have a no talk, or there might be a
Right.
situation in which a board might negotiate away certain of its rights. And of course, all the cases say this isn't it, and we're not. And they had to be fully shopped, and otherwise, maybe it was a distress situation, but fully shopped. But in the context of, I don't have the ability to terminate, and the force the vote essentially doesn't have the ability to terminate. But you have to give the shareholders the right to vote, so it cannot be a done deal. The shareholders, this would have worked if the shareholders had the ability to say, you know what, take a majority of the minority and just say, you know what, I'm not sure I want this deal because I think I'll take my chances with another deal. I think that's all the court was saying.
Now, did you have a problem with the directors who were also shareholders entering into those voting agreements? I guess my question is, didn't they have the right to exercise their powers as a shareholder?
Sure.
Separate and apart from their role as a director?
Absolutely. You can take out Colt and Shaw, and you can't force them to sell to Omnicare. You have to focus in this situation on the fact that for whatever reason they couldn't act by written consent. It wasn't in their charter. And for Delaware 203 purposes, they needed the board to exempt that voting agreement from 203.
Well, that was interesting because the case says there, or there's footnotes to the effect that says that 203 was nobody recalled 203 being addressed.
Well, clearly they did not exempt themselves from 203. I don't know why they didn't, but they didn't. Given the configuration of their shareholders, I would have thought they would have, but they didn't. They needed board approval. So at that point, everyone wants to. I know certainly the vice chancellor and the dissent want to separate the merger agreement from the shareholders.
Right.
But at the point that the board is agreeing to that merger agreement, it doesn't work without that board also taking action to exempt those voting agreements from 203. So the board at that point is blessing the entire package. It's not like they're saying, gee, we like the merger agreement, we've got nothing to do with that voting agreement, and now Colt and Shaw, as shareholders, they can do whatever they want. Once the board has to act on those voting agreements, it's the board's responsibility to take care of the minority shareholders at that point.
I agree, Mort. My question to you, though, is the certificate of incorporation had opted out of 203.
I don't recall that, but if it had, I don't know why they needed the vote.
Agreed.
But
Which
they
is a
did.
question I always had. Why would you make the board a party to the voting agreement as opposed to, like you said, keeping the voting agreement separate and apart from the merger agreement?
But I will say, I guess I would point out that even if they did,
Right.
let's make the assumption that they don't need any board action. They can do whatever they want with their shares. The board still, at the point they're agreeing to the merger agreement, it's not as though they're oblivious to the voting agreement. So they know when they're approving the merger agreement that they're approving a done deal, even if they had no involvement in the voting agreement. So I don't think the board's responsibilities from a fiduciary standpoint change. I think it makes the case, I thought it made our case even easier that the board had voted on that voting agreement. But I'm not sure that the analysis would be different even if they hadn't.
But I agree, it did make your case better when they made the
Not
board
good-
a party to it.
Not good
I
enough
never
for the
understood
vice
it.
chancellor.
No, and as soon as I saw that you opted out of 203, I was like, I really don't understand this at all, what their thinking was. And apparently, you see logically why they might have included the board, because the board was not oblivious to the action, but they really didn't have to.
Yeah, I've never spoken to anybody about why they took that vote or didn't take that vote.
It was very interesting because then when you dig in addition opting out, then the testimony says that there was no recollection of any discussions at 203. So you're like, well, then what were you doing? Not sure I understood that, but
Well,
I still don't.
and again, what's interesting, again, we all do deals in a constrained time period, and you hope that everyone's reading all the documents, but you make sure you go through the documents in great detail. We prepare detailed summaries. We go through all the legal issues. We go through why we're voting on what we're voting on. There's a reference in the decision to, and both the Vice Chancellor and the Supreme Court addressed this well. They only spent an hour discussing this, but the Vice Chancellor says, but it was thoroughly explained to them. The Supreme Court is sort of scratching their head as to, geez, they only spent an hour on this. There was a certain rushed aspect clearly to all this, and it's, did they fully understand exactly what they were voting on and what the consequences were? And the depositions say that they did, and so again, you take that at face value, but again, an hour to go through all the documents in a transaction like this is, in my experience, a short amount of time.
Understood. Now, all those months, as you noted, between April through then, why didn't your client pop up before that last minute?
Because they didn't know what was going on. I mean, they would have been very happy to engage in a process.
But they had no knowledge.
Yeah, no one. The last contact they had with the company was in the fall, and we made it very clear. Omnicare made it clear we're not signing a long-term standstill. We're just not going to do that. But otherwise, and I know Omnicare had a reputation of being unreasonable and hard charges and all that sort of stuff. But they're willing to sign a reasonable NDA, and they did it all the time. They did it before then. They did it after that. They did a lot of deals, and they signed a lot of NDAs. None of them had a lengthy standstill. If anybody had approached them and said, "Look, there's value here. There's a process here. There's, let's negotiate something reasonable and get involved," nobody did. Now, again, if somebody had approached them in April, can I sit here and guarantee you that they would have said, "Okay, gee, we'll be part of the process"? I don't know, but at least they would have had the opportunity. My strong suspicion is that they would have. They would have engaged in a process if they were invited into the process.
Well, before we get into some of the legal issues that were entertained by the court, if I may shift to just a personal reaction from you, how did Omnicare appear to you when you first took them on as a client as compared to their reputation? I mean, did you have any notion of what you were dealing with when you entered into that engagement?
When I started with Omnicare, the first deal I did for them was in the early 90s, and they had a market cap of $110 million.
Right.
We sold them a couple years ago for, I think, close to $14 billion.
Yeah.
They made a lot of money for a lot of shareholders, and they did it by being good at what they do and aggressive, but not over-the-line aggressive from my perspective. I mean, the CEO, Joel Gamunder, was not everybody's cup of tea, but
why not? Tell me.
He was a tough guy. Joel was sort of grew up in a tough neighborhood in the Bronx and went to City College, and then did very well and went to Chicago to business school, and he sort of worked his way up, and then he worked for Peter Grace at Grace, and again, that was no shrinking violet environment. The first board meeting I went to at Omnicare, Peter Grace was still on the board. People weren't sure if he came to board meetings with a gun.
Oh, okay. Now that's interesting.
It was an interesting environment. So but I don't think Joel was any different than any other businessman trying to do the best for his company and his shareholders. He was very successful, which I think led a lot of people to be
Jealous.
unhappy. He could sometimes be gruff, which made people somewhat unhappy. But I've dealt with a lot of business people. They have a lot, they have different styles personally, but in my experience, most successful business people are, they're hard charging and they're trying to do the best for their company and their shareholders. And that means that they're not doing the best, not trying to do the best for your shareholders, they're trying to do the best for their shareholders.
Of course.
And I think that was Joel.
And so Joe might have been difficult, but he was fair with his counsel. You felt he was always open and honest and listened to you.
Yes, absolutely. I mean, if he respected you, he listened to you.
Understood he trusted you too.
Yeah, and I put myself in that category, but taking myself out of it for a minute, there were a few people. He had antitrust counsel, he had regulatory counsel. Joel tried to find people that he thought were really good at what they did,
Yes.
and experienced at what they did, and had good judgment, and he relied on them completely. In fact, Joel would not do anything without consulting counsel. He was obsessed about that.
Good for him.
Completely.
Kept them out of trouble.
Completely. And before the year of governance and all that sort of stuff, he made sure that counsel was at every board meeting, and he made sure that he cleared everything with counsel. He was meticulous about that.
He was ahead of his time.
In some ways.
In some ways.
In some ways.
When you think about Enron, had their books of rules and regulations of corporate governance, won an award for it, and then look what they did. And there's your hard charging.
No, he understood that he was in a regulated industry. That the healthcare was a scrutinized industry, and selling drugs to nursing homes. There's, you don't want to trip up.
No.
And he was very conscious of that.
So tell me, shifting gears just a bit, what did you think of the whole standing argument? You're laughing. What did you?
I'm not a litigator, so
Okay.
I'll let the litigators talk about it.
All right.
But it just struck me as, again, I was going to use the word silly. I shouldn't use the word silly when talking about a judgment of a vice chancellor. But clearly there were cases that established standing for bidders. I don't know why they didn't follow through on that. We obviously had, it just made things a little more cumbersome. It's not like it really made a difference in the case, because we worked through the shareholders, and we were essentially writing the papers and then doing the thinking, and they were involved. Again, I don't want to denigrate the plaintiff's bar, but they clearly serve a purpose. But it's not like that decision was going to do anything other than just make it slightly more cumbersome. So, in retrospect, all of the vice chancellor's decisions kind of went against us. So that doesn't surprise me. But it was not. It was unnecessary, I thought.
But do you agree with his concept of not being able to buy into a lawsuit?
If you thought that that's what we were doing, but I mean, I think the cases are distinguishable between buying a lawsuit or being a bidder and having a legitimate interest in the board's decision-making process. And it also speaks to, if you look at the facts. Again, we all pick our facts. You can look at Omnicare as this predatory, company and industry and horrible people and all of that sort of stuff. If they're really horrible people, they might have been gone out there and got a stake in the equity. They might have taken a stake. They might have thought about ways to pressure the NCS board. They didn't do any of that. That's not what they were about. They simply wanted to do a deal.
your description of how Omnicare is viewed when you read the cases without knowing any of the background is so on point. Is there anything in retrospect you think you could have done differently to convince the court that Omnicare was not the big bad wolf?
You know, I don't know, to be honest with you. There's one thing that sticks out, and again, it came through again, and I remember when it happened, and it came through again in the decision, in the Vice Chancellor's decision. The Vice Chancellor clearly was concerned, I think, about Omnicare, about Unical.
Yes.
And somebody asks Joel, and it may have been in a deposition, it may have been in court, I don't remember when, well, can you buy the combined company? And Joel, being Joel, never one to shirk from a challenge, said, of course. Sure, we can do that. We can do anything. If I could change one fact, I might want to change that, because clearly that he shouldn't have said that. I think he should have said, I want to buy NCS. I don't want to. That's my focus now.
Right, right.
But I think that just embodied Joel, and I think that had he answered that question differently, would it have made a difference? I don't know. But I think it just, in my mind, it probably cemented the view of the court that, yeah, these guys are just
Big shots,
bad guys, and they think they can do anything.
He couldn't. Yeah, he was probably manipulated a bit to bang on his chest a little bit.
Absolutely. Whoever asked that question, I'm sure that was their dream response. And
exactly.
And they got it.
He should have checked with his counsel before answering, just as he checked with everything else.
I don't know where the lawyers were when that question got answered.
Now, tell me, how about the whole transfer argument with respect to the certificate provisions? Did you feel strongly about?
Strongly is a strong word. I thought we had the better of the argument. It was not a solicitation in connection with a 14A solicitation.
Right.
It was, and in fact, as the Supreme Court points out, it's again another fact that they're saying we're not ruling on this, but by the way, once they entered into that agreement, there's no need for solicitation. So to me, it wasn't in connection with a 14A solicitation. It was also distinguishable because there's an irrevocable proxy. When you solicit in connection with 14A, with the proxy rules, you're getting revocable proxies. I thought that we had the better of the argument. I thought that the other side had made a mistake in signing those agreements.
Because you felt it constituted a transfer.
Yeah, we did. Look, sometimes you go into cases, you go into a situation, and you just say, what the heck, let's give it a shot. This could go either way. I'm not sure. But when the client asked us, what do you think about our case? My reaction was, hey, I think we got a winner on the voting agreement. I think we got a winner on the fiduciary duties issues.
Yeah, see, when I looked at that, reading the certificate, I thought, no, this is not a transfer. It's interesting. That was my reaction.
And look, I understand it, and it's not as though it's crazy to come to the other conclusion.
Agreed.
But I thought that if you look again at the way 14A operates, if you look at the distinction between revocable and irrevocable proxies, which is what 14A solicits, if you look at the rights plan litigation and the issues around that, the distinction between revocable and irrevocable proxies, I just thought that we had beneficial ownership distinction between revocable and irrevocable. I just thought we had the better argument.
I didn't think the Exchange Act analysis, I didn't think the decisions went into that kind of detail with respect to the 14A. I really didn't, because some of the points you're making, I didn't take away, and I've read it a number of times.
It's pretty clear at that point that
Yeah.
we were getting slammed by the vice chancellor. We lost the standing argument. We lost that one. And you could sort of see where this was trending at that
So,
point.
okay, knowing that how things were trending, how did you sit down with Joel and say, we're going to keep going because I still think I'm right? And
We thought we were right, and kind of in for a penny, in for a pound kind of thing. We were there, and we weren't going to abandon it unless we absolutely had to.
and so in your mind, there was never a point where you said, this is just not working for us. Maybe we should call it a day.
Again, I'm the corporate lawyer, not the litigator, and I think the litigators probably after the vice chancellor's decision might have said, you know what, this looks a little bit uphill. I'm sitting there as a corporate lawyer just reading cases and not that familiar with the inner workings of the judiciary or that side of the law. It just, to me, it was still, we were involved with Maxwell and that decision. Going back to Anderson, Clayton,
Right.
Ace, Phelps Dodge, QVC. These are stuff that we lived with. We watched the law develop. We were involved in some of those deals.
Mm-hmm.
It just struck me as on all fours with all of those cases. So to me, it was like, gee, yeah, let's go appeal it, because I'm sure the Supreme Court's going to see the wisdom of our view.
Well, they did.
Well,
So,
three
but I
out
would
of five
imagine
did.
Joel trusted your judgment to continue the fight.
Yeah, it was mine and the senior litigators at our firm and at Potter Anderson. And he had great respect for all the senior lawyers he was getting advice from. And I don't think anybody said, gee, let's just stop. There may have been differing views on, obviously it's kind of like, you're in a 7-game World Series and you lose the first 3 games. It gets a little more uphill to come out on top. But everyone said, my recollection is everyone says it's certainly worth continuing at this point. Just another hearing, prepare another set of briefs for the Supreme Court.
But do you remember the Toys R Us, how the board negotiated over a weekend
Yep.
to make their decision? And I have to say that I'm personal friends with one of the board members, so I share that, but I also know that, boy, she worked real hard that week. These people, they were on top of things, and they had a very short period of time to make a decision, and looked like they came out okay on that one.
Well, and if you read the Toys decision, and again, I'm somewhat familiar with that. We represented the banks in that.
Oh, great.
They were very careful. They were very
Yes.
careful about process. But as I said before, you can do deals over a weekend. It's not great for your health or your sleep. But I've done multi-billion-dollar deals over a weekend. I don't recommend it as a regular occurrence, but
It can be done,
oh, absolutely.
and it was done.
And especially if you've already got a fairly well-negotiated document, the process would have been to take it to the other bidder and say, here,
Beat this,
yeah, I'm not going to relitigate a lot of these provisions here.
take it and beat it.
And that's essentially what we did. We once we got a look at the contract, we said, okay, great, we'll sign it.
Did you like that working capital provision?
I mean, it's great for the buyer,
Yeah.
not too good for the seller, but fine. So it's not like at the end of the day we said, oh my gosh, this is going to require weeks and weeks of negotiation. And from the due diligence aspect, again, a great deal is made of conditionality. We would have gotten the information we wanted anyway in negotiating the reps and warranties. I mean, what was important to Omnicare was simply to know, you know, what were the lease arrangements? What were going to be the costs of terminating leases? So you get a contract rep and you get a list of leases, and it's easy enough to see that. And you want to know how many employees they have.
The board just didn't understand that you were going to get the information you needed without putting that due diligence condition, and then that would have really put you in a different position.
You know, it's easy for me as a person that's done a number of transactions, M&A
Right.
deals, that, you know, I do this for a living, to say, we're going to get that information anyway, don't worry about it. It's a very different thing for a business person sitting on a
Agreed.
board. That they're fiduciaries. They take their fiduciary responsibility very seriously also. They wanted to make sure that they weren't stepping into something that an unknown. Now, they wouldn't have, but you know, I understand their position, and I've gone through this with other boards in other situations also. And you know, in virtually every deal that you pick up, in every bid letter, there's, you know, you phrase the diligence differently. You know, we have confirmatory diligence or limited diligence, or everyone tries to minimize it. You're going to get the same amount of diligence.
Correct.
You're going to, in negotiating the contract, it's just
Exactly.
you're going to get it. So, you know, and I think sellers understand that too. You know, so I don't see a lot of beating the drum about how, you know, you got a diligence condition there, and so we're not going to deal with you.
Hey, you have to sign an agreement with schedules that say this is the only thing out there that's a problem.
Exactly.
Okay.
Exactly.
So you almost wonder why parties waste a lot of time with that.
You know, the older I get, the more I ponder why we spend so much time on so much that's irrelevant. But
Yeah,
we do, and you know, look, as lawyers, we get paid to worry and paid
that's our job.
to really sort of dig down and make sure we're not exposing anybody to any real risk. But at the end of the day, you know, all roads lead to Rome. You end up in the same place. You know, you sign an agreement, it's got schedules, you've done your diligence, it all comes out the same place.
Great. So obviously you were very happy when the Supreme Court decision came out. Did it strike you as odd that there was no written opinion, that the written opinion followed months later? So you really didn't understand the grounds on which your decision was made?
I'm not a litigator. I didn't know if that was usual or unusual, but they had to act quickly because
Right.
you know, this was a dynamic, moving situation. I don't think nobody would have hung around for another 6 months to wait for a decision. You want to get a deal done. So it didn't strike me as unusual, but you know, the litigators might have a different viewpoint on that.
And when the decision did come out, what did you think of the dissent? Obviously, it was accepting all the facts as, you know, you may have focused on different facts, but what was your reaction?
I mean, obviously I thought the dissent was wrong. I found it curious that, you know, the chief judge who had written Paramount didn't see the parallels to the QVC situation. And you know, if you assume a certain set of facts, like Omnicare was never really there, and Omnicare came in after the decisions were made to sign the exclusivity and
Right.
and the bird in hand, as opposed to just the
Right.
fly by night last minute guy. I'm not saying that I don't understand his reasoning, but it's still difficult to square with the decision he wrote in QVC, which is very clear you cannot block another bidder. It's very clear that you've got to be able to, if you think something's conditional, you know, the QVC bid you thought was too conditional, there's an obligation to investigate that. Now, you know, they go out of their way, the dissents go out of their way to talk about how this was last minute and the precipitous nature of the company, and if they didn't do this, they might have
Right.
gone back into bankruptcy. Well, it's pretty clear at that point this company wasn't going bankrupt, and there wasn't that urgency. So I got great respect for the Delaware judiciary. I just thought they were wrong.
Well,
And not consistent with the precedent. The other thing they did was they made a point, forgive me if I go on about this.
no, please, go ahead.
They made a point of this is new law. And to me, I mean, I always found that curious. And boy, we hope this is sui generis and this will never happen again. Well, you know, I suppose that getting a control person and locking it up doesn't come up every day. But to me, it wasn't new law. It was, it was very consistent with all the cases that had preceded it, which is, you can't be preclusive and coercive. And this was just in those line of cases, and I think that's all the majority was saying. You can't pre-wire a vote.
And you think I felt as if the dissent was saying, look, these were egregious circumstances because of the facts as they saw them. And you had to leave room for a board to be able to act in this manner.
Well, although again, the case law is pretty clear that you can't create the situation that creates that exigency.
Well, that's true.
And to me, again, you pick your facts, but they created the situation. They could have come and spoken. They could have reached out to Omnicare. They didn't. Then all of a sudden, Omnicare's bid is at the last minute. Omnicare might not have bid at all on that day. Judy Mencher not reached out to them. So, it's you can all paint it as last minute. But if someone had reached out to them in June, they would have lobbed the bid in June.
Do you think Judy reached out with the support of the rest of the board, or do you believe this was an action she did independently from the board?
I have a sense she did it on her own.
Wow.
I mean, again, I don't know.
I know. We're guessing.
Yes.
But what does that tell you?
Well, she did what, to me, I've been involved in a couple of bankruptcy sales. She did what every creditor's committee does, and every creditor does. They care about 100 cents on the dollar.
Sure.
Plus interest. I suspect she didn't see that coming from Genesis. And what she did actually prodded Genesis into doing that. But at the time, and I'm not sure what her motivation was. Was her motivation to really get Omnicare involved, or was her motivation to see if she could jack up Genesis, and maybe a little of both? It was kind of a win-win for her.
Or maybe she wanted to create a record that the board was giving an opportunity.
Yeah, I don't think she was be too concerned about the record. I think she was worried about
the money.
The money. I think some of the actions of the board after the fact started to pay lip service to fiduciary duties and Unical and that sort of stuff. But at that point in time, I don't think the creditors had any concerns about that.
What did you think of Genesis's negotiation of a fee at the end?
The termination fee?
Yeah.
We wanted to get rid of them. They realized that they weren't going to top us. They were going to be gone. They were. We were willing to pay them so that we didn't have to wait till the drop dead date in the merger agreement. There was some sensitivity on their part. They were concerned about the size. I think they didn't want anybody to come back and say, wait a minute, that was money that could have gone to shareholders, and maybe that was a little bit excessive. So there was some consideration of that. But otherwise, at that point, I think they were just trying to get as much as they could to cover their expenses.
And you felt it was a cost of doing business.
Yes. I mean, again, these deals were incredibly accretive to Omnicare. Mm-hmm. And so it was not that, again, you'd rather not spend the money than spend the money, but in order to get the deal done, sure.
Well, I think, so the quandary really comes at the point of, do you, when you think you're in an exigent situation, have to still stop and give a potential bidder an opportunity. And I suppose that's where I saw the disagreement with them. And I agree with you that pay attention to maybe some different facts than others, and the outcome's a bit different.
And I think the case law, even again, if you read Phelps, Dodge, and Ace, which were really, very much on my mind when we went into this, because those were 1999 cases, they say, look, there might be situations in which you, say, cut off a fiduciary out. And again, there's confusion about that. They're saying you can do a fiduciary, you can cut out the fiduciary out, but you still need to let the shareholders vote. So it can't be wired. So you can give people, depending on the circumstances, if you have a completely shop deal, you have a company that might be in dire circumstances, you can conjure up situations in which, okay, I've got to give them more than not, but still, so I can avoid talk. It takes to say the no talk, which was in Phelps Dodge. Maybe you can give that again in this day and age. It's never going to come up again. No one would ever do that, I don't think. But back then, I think I don't think the Delaware judiciary ever want to say there's something you absolutely there are no hard and fast rules. I'm not sure that Omnicare is a hard and fast rule either, other than you got to give people, ultimately the shareholders, the right to vote. So I don't have to talk to you, but that means that doesn't preclude you from saying, okay, but I'm here and I'm making a bid, and shareholders be aware that I'm here, and now vote. Take the bird in hand, or maybe take run a risk with me. But again, I think those are extreme, if you read the cases, extreme circumstances. And even if you say that NCS was in that extreme circumstance, the one thing they didn't do is they didn't shop the company. They didn't really, had they gone to Omnicare, if the facts were that they'd gone to Omnicare in April or May before they signed the exclusivity agreement, Omnicare said, I just don't care. I don't care what you guys are saying. I'm never paying anything for the equity. Go away. Don't bother me. I'm going to pick up your bones in bankruptcy. If those were the facts, then I could see a situation where they could say, okay, we don't have to talk to them, but still give the shareholders the ability to really vote. And in this case, the minority, the board should be protecting. But that wasn't the case, and which is again why I thought we were just very consistent with the previous case law.
Is there anything else that you can remember from the case that you thought was significant, that surprised you, or that you...
The whole thing was surprising to me, frankly. I mean, it was, but other than the fact that we kept losing these decisions, no, I mean, Genesis' approach didn't surprise me. They obviously they were doing what was best for them. I guess at the end of the day, what surprised me a little bit was just the NCS board. Basically, Genesis is telling you, I want these lockups because I don't want Omnicare to bid. At that point, you might have thought, well, gee, maybe I can get more out of Omnicare if I go talk to them. It's somewhat inexplicable to me that they didn't do that. So, if there's a surprise in this, that would be the surprise, but they didn't, and we ended up where we ended up.
And I imagine that since then, and you always see a fiduciary duty out in your agreements.
Yes, and in the rare cases where you have a majority owner, I mean, we structured it so that it's not a fait accompli. And again, there are ways around this. It's if somebody has a majority, you can get a voting agreement for 35%. Sometimes we've done that. But the other aspect of that is nobody wants to be locked up completely. So even when we get voting agreements that stop short of a majority, they all unravel if the board exercises their fiduciary out or the board changes its recommendation. Because that majority buyer wants as much money as he can get. It's sort of commonsensical.
Of course.
So when, in the dissent, Judge Vesey talks about hopefully this will never happen again, sui generis. I think it won't happen again just because the market has moved away. No one's going to ignore a better bidder. I just don't think that will happen today.
And I suppose that's the whole thing as to whether or not the fiduciary outs really work is how you define what a better bid is and how much latitude is given to the board to make that determination as to whether or not it's really as valuable as you'd like to think.
Well, you negotiate, what's a superior proposal, but
right.
Again, these things have a way of becoming market standards. So things that you negotiated ad nauseum 10 years ago, today it's like, you'll play around at the edges, but everybody more or less understands what a superior proposal is. Sometimes somebody will have a new bright idea and, you have to negotiate that. But it's now pretty standard. And, and you have a superior proposal, you have matching rights, you argue about whether it's 3 days, 4 days, 2 days, and 10 hours. But, you essentially get to the same place because I can't imagine somebody saying, you know what, I really don't want the highest bid. I don't want more money.
I'll take less money.
Yeah. It's not going to happen today. I just don't see people doing that. And if someone decided that they want to do that, they'd have their shareholders in the whole corporate governance world to answer to. It's just not going to happen.
If the option to act by written consent was available, do you believe that might have changed the outcome, or do you believe that's form over substance?
Well, in some senses it is form over substance, but that's the way lawyers live. Some charters have certain provisions, some others have others. There's staggered boards.
Right.
There's, shareholders can call meetings in some situations. In other situations, they can't. People, and the governance community has their views on some of these provisions, but they're there, and you live with the provisions in your charter. That's your contract with your shareholders. So if they could have acted by written consent, that would have potentially changed the issue. What's interesting to me always about the written consent issue is it doesn't become effective if you're a public company until you issue an information statement. I think it's a 20-day lapse. Now, to my knowledge, this case hasn't arisen, but theoretically, you could act by written consent, and somebody could come along before that consent is effective and say, gee, I'll pay you 5 times more. I'm not sure exactly what people would do in that situation. I know, obviously, the acquirer would want to insist on the validity of the written consent. And I don't know.
It's an interesting.
I don't know what a court would do with that. But taking that wrinkle out of it for a moment, if you can act by written consent, you can act by written consent. If that's what's in your charter, sure, that's your contract with your shareholders.
Did you think that the director shareholders that gave the proxy and entered into the voting agreement, did you think their interests were aligned with the minority shareholders? Everybody wanted to get money and come out a winner.
Everybody always likes money. Outcall had a consulting agreement, and the vice chancellor minimizes that, or one of the opinions minimizes that. But again, that's money. They say, well, it wasn't enough relative to his net worth or what he was getting in the deal to make a difference. But it's something he got that other shareholders didn't get,
but it wasn't significant.
It's not significant, but if you sort of put it in the context of an all holders best price world, and I understand that's tender offer, and he'd then have to consider whether that's really consideration for his shares or is that consideration for other things. But he got more than other shareholders. With respect to Shaw, it's very clear he was not going to be an employee of Omnicare. Although I think that Joel at some point after the fact may have said, we'll consider continuing employment, but he wasn't going to be CEO of a public company anymore. That was for sure. There was obviously no written agreements with Genesis, but Genesis had some senior leadership vacancies. So
sure, it's consideration.
I'm sure that was, he's human. That probably entered into his thinking. I don't know if there were any conversations on that point or not. So there was a possibility of employment there. There was no possibility of employment for him at Omnicare. Did that factor in?
That wasn't really focused on very much.
No. Look, you can dislike someone, and I get it, Not everybody likes me, not everybody likes, I don't like everybody, and not everybody likes Joel Gamunder. But to take that dislike and to translate that into a negative impact on the financial situation, I don't get that. So you really got to dislike someone to say, I'm going to spite myself. I'm going to take less money because I really don't like you. Maybe that happened, but it just struck me that there had to be more going on.
Yeah, but at that time, they didn't really know there was going to be that much more money coming from you.
But they didn't ask. It's, again, a normal bidder. A normal seller would have at least explored the possibility, because you'd want more money. Everyone generally wants more rather than less. The fact that they didn't, the fact they went out of their way, it seemed to me not to. It always struck me as curious.
Maybe as opposed to dislike, maybe it was more of a trust issue based on nothing more than reputation.
Yeah, no, and they make a lot about that. But I didn't do every deal Omnicare did. They did a lot of deals, but we did a number of deals for them, and they never reneged. I never saw them say, we're going to do this deal, and then at the last minute, oh, gee, we're not, unless we have a price reduction or unless you give something else. It just, in part because their business model depended on acquisitions. It all slowed down, actually, when they got so big that the smaller acquisitions didn't have much of an impact on their per share value accretion. So they would have been basically shooting themselves in the foot to renege. Their whole business model was, we've got to do acquisitions. Did people think that they drove a hard bargain? Yeah, maybe, but no one said, "Oh my God, they're going to do a bait and switch on you, and they're not going to close, or they're going to drastically reduce the price." That's just not the way they operated.
Anything else you'd like to add before we end?
I think we've covered it.
Well, thank you. It's been a very interesting conversation with you, Morton.
Well, thank you.